Good afternoon, everybody. I'd like to thank everyone for joining us today. This is a very hot topic, especially with the regulations that are coming out next Friday, actually, September 22nd. This is the bulk of the law is coming into effect next Friday. So this is very timely. I'd like to thank Alan again for joining us. We did a webinar like this in May, I believe, or in the spring. So there's a lot to cover with this. I just want to introduce Alan. He's the official legal counsel for Cake Mail. If you go to allenmendelsohn.ca, he's an internet law and privacy specialist. He also teaches at the faculty of McGill. And I believe it was his birthday last week. Is that correct, Alan?
That is correct.
Happy birthday. Happy belated birthday.
I'm a young 29 years old.
Me too. I'll let you go ahead.
Thanks so much, Kevin. And generally, thanks to Cake Mail for inviting me here today. Thanks specifically to both you, Kevin, and Isabel, for all your help and having me here. And thanks to everyone out there for coming here today. I know how important this topic is to everyone. Quick correction. Kevin said my website is allenmendelsohn.ca. I
Sorry.
think that might auto forward to
Yeah.
allenmendelsohn.com. Anyway,
.com.
you search my name. I'm easy to find. I'm the only real important Allen Mendelsohn out there, if I do say so myself. Although there is some Hollywood producer, but yeah, forget it, Hollywood. Um, and just to add for anyone who wants to know, a few more things about me. I do have background, sort of a tech background. I was vice president of an internet company for 5 years. And then I've been a lawyer for more than 20, sort of combining both my technology love and my legal skills. And I've had my own practice in internet law for the last 13 years or so. Internet law being a pretty broad term, which of course includes privacy. And if you look at my email signature, it in fact says, I think in order, internet, comma, privacy, comma, and technology law. And for the last 7 years, I've been teaching at the Faculty of Law at McGill University, which you can see behind me. Obviously, it's not real given, oh no, it's getting sunnier out there today. So it might sort of look like what it is. Um, Time to panic. Or is it? You're staring at that in front of you. Well, the countdown clock is counting. Maybe a little dramatic to use a nuclear explosion for September 22nd, about 8 days and just under 11 hours now, when the big new parts of the law come into effect. But it's a metaphor. It's a metaphor for the fact that this is really an explosion of a privacy law for North America. For Canada, certainly. There's a few American privacy laws that are quite similar to what we are getting here in Quebec in 8 days and approximately 11 hours. But in Canada, certainly we are here in Quebec well ahead of the field. And, it certainly might be inducing panic in a lot of you. So, hopefully we can ease some of your fears. And, maybe knowing that you're all sort of in the same boat might help ease some of those fears. This is the graphic in front of you. There was a study of a bunch of more than 100 organizations that the law firm Gowlings, along with the Interactive Advertising Bureau of Canada, put together a study to get people's reactions and fears about Law 25 and the Quebec privacy law that's coming into effect. And as you can see, everyone's concerned about it. And companies, more than half the companies say they just don't have the resources to deal with it. And more than 2/3 of companies, need some clarity around what Law 25's practical requirements are. And, hopefully, we can answer some of those today. But I'll be honest with you, I need some clarity as well from the Commission d'accès à l'information, which is the Quebec Privacy Authority. And I'll talk about them a little bit more coming up. Just to take a step back here, I'm sure all of you know this by now, but let's let's take a look, just remind ourselves about what Law 25 actually is. Law 25 was Bill 64. It's now Law 25, and it updates the existing Quebec law, the loi sur la protection des renseignements personnels dans le secteur privé, which we shorthand en français to loi sur la privée, and we shorthand in English to the Private Sector Act or the Quebec Privacy Act. You know, there is actually a Quebec Privacy Act, although it's a minor little law, but generally a lot of Anglophone lawyers like myself do say the Quebec Privacy Act when referring to the act respecting the protection of personal information in the private sector, which is a mouthful. And if it wasn't in front of me, I'd have problems saying it as well. So Law 25 amends that existing law and amends it dramatically, essentially making it an entirely new law. What was a very, very weak privacy law will now be, as of September 22nd, a privacy law that, you know, rivals the GDPR. I think it's also important to remind ourselves, and I did have the same slide in our May presentation, that there is a much broader geographical scope to Law 25 or the Quebec Privacy Act, in that while it's not explicit in the law, the Commission d'accès à l'information, which I may just say commission from now on, just so you know, the Commission, they take the view that as long as you're collecting personal information from an individual in Quebec, it doesn't matter where you are. And in fact, I was reading something today from that Gowling report where I got that slide earlier. And a good friend of mine, actually, the head of privacy at Gowling's, Antoine Guillemin, said very explicitly in that report that the Law 25, the Quebec Privacy Act, as amended by Law 25, has extraterritorial application. What that means is it extends beyond Quebec's borders. So, you know, many of you out there are outside Quebec. Don't think that you're getting away with things by being outside Quebec. As soon as you collect personal information from an individual in Quebec, you will be subject to the Quebec law. All right.
That includes Europe. I mean, obviously, it's going to be difficult to enforce this outside of Canada.
It sure does, Kevin. You know, Kevin, that's a great point. You know, it's going to be difficult to enforce it from someone even in Ottawa, let alone someone in Budapest. I mean, like the Commission d'accès à l'information has limited resources. I have not even really heard about a massive increase in funding for the Commission in order to properly enforce this law. So it's going to be difficult enough for them to enforce it to Quebec companies, let alone starting to stretch their reach for, you know, for anyone outside, whether they be in Ottawa or Paris. You know, it'll be interesting to note, and I in some ways, I almost wish they would. I would love to see them try and enforce a big penalty against a foreign company, because that foreign company would undoubtedly take the Commission to court. And we could get a lot of clarity as to the extraterritorial application. Because right now, all we really have is the Commission's word that it's applicable outside of Quebec. So, you know, I almost welcome they would do that. And you never know, the Commission, like the European privacy authorities when the GDPR came into effect, the Quebec privacy authorities may decide to make a big splash very soon by finding some big target, a Google, a Facebook, and whatever, and slapping some administrative monetary penalty on them just to say, hey, look out, guys, we're here and we've got these giant penalties too, pay attention. So it'd be interesting to see if that actually plays out this fall or this coming spring. But it's a good point, Kevin.
Yeah, Castle kind of rolled out the same way. I don't, correct me if I'm wrong, I don't believe there've been any international, you know, who's hasn't adhered to Castle, and
The
it's just
castle.
been
No, not to my knowledge. All of the big
yeah.
penalties, the ones that I remember at least, were all Canadian companies. There was a big Rogers one. There was a big, the one that
Mhm.
ended up in court was an Ontario company. So yeah, you're right on that point. But they certainly, the castle regulators definitely did make a big splash by going after Rogers. I thought when they did that. So that's kind of what I'm thinking of might happen.
Yeah, I mean, don't get us wrong. This is obviously a step in the right direction. The privacy laws are not going away. They're, only going to get stricter. It's going to be really interesting how AI will play into this. But
Yeah. Oh, yeah. No.
yeah,
Well, let's don't mention AI, Kevin. This
that just
meeting is
opens
this
an entirely
this talk is complicated enough.
yeah, it's a whole different can of worms. It's going to be very interesting. There's a lot of data that's being collected on a lot of people, and it's everywhere.
All
That's not
right.
going.
Yeah. Yeah. All right. So
Hey,
now everyone out there is staring at the slide that's in front of them, where I have attempted to summarize what I normally have in about 5 or 6 slides onto one slide, which is all the things that are going into effect in 8 days and now 10 hours and 46 minutes by my laptop clock here. So just to quickly point out what they are, maybe say 1 or 2 words about each one of them. So these internal governance policies and practices, that's sort of a big new thing. Now, most companies, or at least companies who are very concerned about security, have had various governance policies in place in the past, but now the law requires you to have them, very specifically 3 types of governance types. And they are, you have to have a framework for the treatment of personal information. You have to have a framework for dealing with complaints, and you have to have a framework that explains the employee's responsibilities throughout the life cycle when you collect, use, and disclose, to use the Canadian natural phrase, personal information. So those are the 3 types. There's also now, for the first time in the Quebec law, there's mandatory data breach reporting. We've had that in the federal law, PAPETA, for a while, but it's now in the Quebec law as well. And the Quebec law doesn't specifically or explicitly state that you should have a policy for dealing with data breaches, but given the important penalties for not reporting data breaches, and the just from a security and privacy standpoint, certainly a data breach practice and procedure is a good idea. Probably the most important one, and in some ways the easiest one to deal with, of what's going into effect soon, is in those 8 days, is the second one, is the obligation to inform in clear and simple language, which just requires a lawyer, or yourselves, if possible, draft reworking their privacy policies to make it much simpler. Use language that individuals can understand, that a normal person can understand, as opposed to all the legal language that I have been drafting for all of my career, essentially. That one's sort of the easiest thing that you can check off a list, because there's very little guidance required. It's sort of redraft your privacy policy to make it clear and simple. The new consent rules are a little more complicated. In fact, a lot more complicated. Basically, I think this has been good practice for a long time anyway, but only collect the personal information that are absolutely required for the purposes for which you're collecting it, not necessarily the consent rule, but it's the sort of the main rule. And then it's easier to get consent, and your consent must be clear and enlightened, and informed is the phrase used in the French version, informed. So to get informed consent, you need to have a good privacy policy that explains what personal information you're collecting, why you're collecting it, what you're using it for, who you transfer it to. Right to de-indexation. Well, someone asks you to take off a link that's to their name that you may have on your website, you do it. There are some exceptions in the rule, but anyway, that one's pretty easy to do. A big thing that I've been noticing from clients lately is how long can I keep my personal information? I've collected the personal information and I need that personal information. It helps to train my AI system. That's a big one that I've been getting a lot lately. I tell them, well, the Quebec law is now very, very, very specific. As soon as the purpose for which you've collected the personal information is done, you must destroy it. It's as simple as that. Or you can anonymize it. And by anonymizing, it sort of says in the law to the, using the normal practices. But to be clear, anonymization must be final, i.e., you could not combine it with other information to make it personal information once again. So, for any of you out there who need that personal information to help train your computer systems, whatever smart technology or AI technology you're using, we've got to anonymize it in the first place. So those cookie banners that we've been seeing forever, they're not explicitly mentioned in Law 25, but what is explicitly mentioned in Law 25 is that if you want to use technology to track people's preferences or locations or a couple of other things, you must tell those individuals how to turn on that technology. And what does all that mean in a practical universe? Practical universe means a cookie banner with non-essential cookies off by default, because tracking technology for location, for preferences, etc., those are non-essential cookies. So if you want to tell people how to turn them on, you have a cookie banner where the default is off, and then you can have them turn it on, and that's your method for turning them on. Now, again, these can be, and I've been telling clients this recently, geo-targeted. So only have that default off, non-essential cookies off by default to geo-targeted people in Quebec. Remember, the law applies to collecting personal information, and personal information includes those advertising identifiers that are, collected through a cookie. So there you go. That's sort of where those cookie consent banners come into play. Not explicit, but it's the easiest way to deal with that particular requirement. Highest level of confidentiality is the phrase used by the law, which a phrase that is privacy by design and by default is the equivalent phrase in the GDPR, which is a much cleaner phrase. Basically means you must, if you have a technology product, and I assume just about everyone listening to the sound of my voice has a technology product, you have something on the internet, it's a technology product. And that means you really must take the most privacy as seriously as you possibly can. And if you're collecting personal information that's sensitive, health information, for example, you've got to ratchet up your level of privacy. And remember, confidentiality is what the translator has badly translated. It's privacy. Inform individuals if you're using AI, it's simple enough. The practical perspective as of September 22nd. Now, you're supposed to be signing DPAs. Now, it does not say, again, it's one of those things, does not specifically or explicitly rather say data processing addendums in the law. But what Law 25 does say is that if you are going to transfer personal information to a third-party service provider, you must establish that mandate in writing, and that mandate in writing must describe several things. And the things that it describes, if you read the law, what it must describe, it's essentially a data processing addendum that we have been seeing under the GDPR since the GDPR came into force 6 years ago. So you're going to have to think about signing agreements with your service providers. Now, I'm sure your service providers are thinking about it themselves, but certainly as part of what you want to do is look at those. And then finally, the famous privacy impact assessments, which the law calls the assessment of privacy related factors that you have to do in two situations, specifically when you are designing some sort of new technology service, and two, when you are sending personal information outside of Quebec. Now, you may ask yourself, well, how do I do a privacy impact assessment that conforms to the law? Well, you'd think that the Commission would tell us, and they have not. So I showed this slide in May, and I know Kevin was very interested to find out when this guide that the Commission would in fact be made up to date, because the guide continues to say on its cover, this is not up to date. It's going to be changed by Law 25. We're going to revise it. Well, still that same old guide. Now, the Commission, sorry, go ahead, Kevin.
Yeah, we did mention this in May. It's a good point.
Yeah.
And if you click on that link, actually, when this eventually does get updated, hopefully we'll let everyone know that that's on the webinar today, including Cape Mill clients as well, because it's an important part of it, and it's kind of a confusing part of it. So anyway,
yeah, 100%. We're all very much waiting for this guide to get updated now. So the Commission has updated their page of information about privacy impact assessments. That's the link that I've put on this slide. It is up to date to August. So it does talk about those two situations I just mentioned to you. So it's telling you when you have to do a PIA, but it doesn't tell you what's supposed to be in that PIA. So that's not particularly helpful. And they really have it, I swear on my life, in a thicker, different font, that phrase at the bottom, telling us that soon there is going to be a guide to tell us how to do PIAs. Well, we've been waiting. We've been waiting. Anyway, someday, hopefully, it'll come. Doesn't look like it's coming before September 22nd, however.
Yeah, they're going to release it next Thursday with the 24
it's
hours.
Very possible, Kevin. That would be funny. We all get a good laugh out of that one. So just a reminder, why this is all important is the penalties that are available, that are possible under the Quebec Privacy Act as amended. 3 different kinds of penalties. They're sort of administered in a different way. But of course, the thing everyone focuses on is that number in the bottom, on that first column, the penal offenses, the 25 million or 4% of worldwide turnover, which is just sales. So that's obviously a big number. I like to also look at that last column, which is a doozy. And a private right of action basically means that you can be sued by individuals for certain parts of violating the Privacy Act. And, getting sued by one individual is not going to be the end of the world. But what is going to happen, I guarantee it, and I guarantee because I know several class action lawyers, that class action lawyers are already putting together lawsuits as a class action to sue based on Law 25. So that's what companies should be concerned about, not an individual lawsuit, but a class action lawsuit, which theoretically is going to be possible as of September 22nd.
It's important to mention there that as well, the penalties, it's up to that amount. It can be anything up to that amount. Yeah, it's not
Yeah. Sorry. It's just so we're clear. A small company or a medium-sized company. Let's call Cake Mail a company of Cake Mail size. Although Cake Mail is going to be Law 25 compliant, if I have anything to say about it, and they've been working diligently to do so. So I'm not worried about them. But smaller companies and medium-sized companies, would not get fined 25 million or massive amounts, but fines are certainly possible, of any amount. So, and again, well, we're going to have to see. Like, as Kevin and I were talking before, we're going to have to see how this all plays out in terms of the enforcement.
Yeah,
So
it's
to go ahead, Kevin.
the law has to have teeth. So I mean that number has teeth. So it's there for a reason. But
100%.
it's not there to
100%.
bankrupt or stifle business in Quebec. But
No, 100%. For years, since I started practicing in this area, I called the federal law PAPETA and Quebec's law toothless. It was the easiest way to describe the law. And people would ask me, what happens if I don't adhere to PAPETA? I say, nothing. Like, literally nothing. And the same thing under the Quebec law, meaning that there were no financial penalties for the most part, and the privacy authorities had virtually no power to enforce the law. Both of those things are now completely different, or will be completely different, in 8 days and 10.5 hours.
game changers.
Yeah, 100%. That's why the GDPR was a game changer. And that's why this law is a game changer. It's those enforcements. So, as I was just saying, Cake Mail, along with myself, has been working on their compliance program and sort of getting ready for Law 25. So, Kevin and I have worked on sort of this checklist that you see in front of you. And, it's what Cake Mail has generally done, in order to sort of get ready for 8 days from now. So, before I say a few words, Kevin, do you want to say a few words about this list?
Yeah, I think it's a great checklist. It's important to. Well, I mean, we did a lot of this for the GDPR a few years ago, so it was just basically tightening it up and, appointing a data protection officer. Obviously, that's heavily built into the law. It falls back to the CEO of the company. I don't know a lot of CEOs that have time to focus on privacy, but it does fall on their shoulders if you don't appoint a privacy officer. Number one. I'll let you talk about the framework, but yeah, that was a big step.
I mean, there's several things to be. It's sort of, I think 2 and 7 kind of go together. Your framework can sort of be built into your internal policies. As I was talking about, the 3 policies that are required under the law, and as well the one we recommend, the data response plan in case of a data breach. You definitely want to talk about, and that's very much, those documents and the sort of the framework generally are very much technical documents. They're a lot less legal and they're much more technical. What procedures are in place to store personal information securely? Who has access to that information? And remembering that the law states that only those employees who need to have access to the information by information, I mean personal information, to do their job should have access. So it's all about sort of prioritizing privacy and, protection of personal information. You sort of need to think of it as the front line, as almost the first thing. That privacy by design and by default, for technology products that I was talking about earlier, that means that every decision you make has to have privacy, protection of personal information, as the first question you ask. So, your framework needs to reflect that.
I always wondered, thankfully it hasn't happened to Cake Mail, but say there is a data breach and you do report it to CIE, what happens after that? Are they appointing an officer that'll work with you to go through everything? How do you see that playing out?
What generally what happens is they thank you for informing them. I have well, let's be clear about something. I have yet to file one with the CAI, but I have filed them with the Office of the Privacy Commissioner because, like I said, the data breach requirements have been in effect in Canada for many years now. So I've had the opportunity to do those. So I'm speaking more about what the Office of the Privacy Commissioner has done, but I expect that the CII will do the same. And actually, I did help a client inform the CII even when they didn't have to. And they were basically, they said, okay, thank you. Have you informed the individuals involved? You say yes, because remember, for both PIPEDA and the new rules under the CAI, under the Quebec Privacy Act, that you must report it both to the privacy authorities, i.e., the Office of the Privacy Commissioner federally and the CAI provincially, and the individuals affected. Now, there are not limitations, maybe the wrong word, but there are circumstances when you are supposed to report it or when you don't have to report it. So you may want to consult a lawyer to help you sort of evaluate, or more importantly, you consult your insurance company. You want to let your insurance company know first thing, and they'll help you out. So there's a real practical piece of advice. If you have a data breach, if it's nasty, like if there's a lot of financial information stolen, you tell the police first and then your insurance company, although maybe even your insurance company first. And if you have internal counsel, obviously tell them first. But your insurance company is going to want to know first, and they will help you sort of with the procedures of all of that. Sorry, getting back, I have made that's quite the left turn, Kevin. It's not what you asked me. But I thought that information was important to get out there, sort of practical information in case of a data breach. So so the privacy authorities generally will say, have you informed the individuals that were affected? You'll say yes. They'll say, can we have a copy of that whatever letter or email, generally email, that you sent to all the individuals? Say yes. And in fact, there's a form that you have to fill out. I have seen both the CAI form and the federal form and helped my clients fill it out. And that federal form asks you to put on, as an appendix, what you sent off. Generally, they acknowledge receipt of in all the circumstances that I have dealt with so far, they acknowledge receipt of the report and they say thank you, and you never hear from them again. So that's, I have never had a client have what I would say a real serious data breach. One that deals with hundreds of thousands of individuals, social insurance numbers, and credit card data. So, in those circumstances, I expect that, the privacy authorities, whether they be federal or provincial, would very much be much more involved detailed wise.
Yeah, I would think if this was a reoccurring problem and they kept coming up on their radar, they might take a little more action, but it's good to know. I mean, I've certainly received emails saying my password's been compromised. Please log into your account and change it. I mean, it's been only with companies in the States up until now, but this definitely makes sense. That's why it was written into the law in the first place. It makes perfect sense. Moving on to client communication, I mean, that's a big part of what I've been doing, just communicating not only through these webinars, but we've done blog posts as well. We've sent emails to our clients, letting them know we're also doing changes to our privacy policy. So as soon as that happens and that's updated, we'll communicate that accordingly. The cross-border data, yeah, that's interesting. You mentioned the interprovincial, so it includes that as well.
Sorry, no, that is a typo on my behalf. I meant interprovincial. I'm noticing it now. Let's be clear about that, and I apologize and I will fix it. I'm making a note of that right now. Geez, that is embarrassing. So yeah. So well, it says IE from Quebec to other provinces. So that's really what I meant, which is interprovincial as opposed to intra-provincial. So yeah, so again, as I was mentioning, for most specifically for those privacy impact assessments, that they are required when personal information leaves Quebec. And there's also sort of a general, what I call BS statements in the law about, well, if you're going to transfer it outside Quebec, you have to make sure the company outside Quebec will give the personal information the same protection as a company inside Quebec would. Well, give me a break. I mean, frankly, I trust the security of many, other companies, more than I would certain Quebec companies. So, but yes, it's a big part of it. And it's also like, and that's another big part of, if you are a non-Quebec company who is collecting personal information from Quebecers, by definition, all of your information is leaving Quebec. And there's going to be, implications there. So that's certainly a big factor. Kevin, I'm noticing time is ticking away here, and we've got
Yep.
about 20 minutes left. And I know we wanted to have a big question period, so I think maybe we should turn to that question period now. Just a reminder. I mean, I see I haven't looked in the chat yet, but please go ahead. And yes, I see there's several questions in the chat already. And I certainly will answer them. Et oui, n'hésitez pas à me poser des questions en français. Il n'y a pas de problème, je vais vous répondre en français. De temps en temps, j'utilise des termes en anglais, mais je vais faire mon meilleur pour utiliser des termes français. Je peux vous dire, oui, je vois en français, renseignement personnel, that's personal information. And if anyone prefers to ask a question, live, please go ahead and raise your hand, and we can unmute you and check. So let's see.
Yeah, if for whatever reason we're not able to get to your question, by all means, you can email Alan, or you can email privacy@capemail.com. I'll make sure that gets answered correctly. One thing I did want to mention on that last slide, though, quickly, Alan, is to evaluate and update your insurance coverage. A lot of people might not take that into account. They might not, think about the insurance. What's the how is that going to happen? But it's definitely important. So take a look at the insurance company you have now for breach, and if evaluated and make sure that it's up to date, because that could really come into some serious financial problems.
100%. And that's just good advice generally, not just for Law 25. Everyone, listening to the sound of my voice should be evaluating their cybersecurity coverage. Some people don't even have it, or don't know if they have it, or when they have it, they find out it's only $10,000 or $20,000, and that's not going to do anything. So that's a very good message, Kevin. Okay, let's start answering some questions. Here's a question for the DPAs. Do we need to have one for each mandate, or can we have an agreement with our clients that would cover every mandate of the same type? It's a good question. Think of a DPA as just an annex to a service agreement. So if all of the work you're doing is covered under one service agreement, you only need one DPA. Maybe you have to amend it if you start collecting different personal information based on whatever that particular mandate is. But if you think of a DPA as just a big section, even not even as an appendix or an annex to a service agreement, that's your answer right there. Do you have a new agreement? Well, then you need a new DPA. But if everything you're doing is under one particular agreement, I would say the same DPA could be used. I think that would be the best way to look at it. And okay, it's not really a question, but Anonymous makes a very good point. I'd like to read Anonymous's point. And I'll translate if anyone doesn't understand what I say. Pour les incidents à préjudice sérieux, ils vont demander d'évaluer le sérieux du préjudice, de leur faire rapport et de leur fournir copie des avis transmis aux clients et de mesures prises pour éviter que ne se reproduisent ou alors avoir moins d'impact si le reproduit. So Anonymous, I'm guessing, is sort of answering the question that Kevin and I were talking about as to what the privacy authorities would be asking you in the case of a data breach incident. And he's absolutely right. And so they're going to ask you to evaluate the injury, the damages, are they serious? So again, to send a copy of the what you sent to those covered, and the measures taken to prevent it, that you're going to put in place to prevent it from happening again. And indeed, they will ask you all of those. And I didn't go into those details, but all of those questions are on the forms that both the Office of the Privacy Commissioner and the Commission provide to you, as well as just sort of basic information, but all of those questions are on there. Thank you very much, Anonymous, for pointing those out.
Alan,
yeah.
On a beaucoup de nos clients qui sont dans ce webinaire et puis il y a une question que quelqu'un vient de poser, que j'imagine plusieurs personnes se posent. Quand on utilise CakeMail ou Courriella, vous hébergez des contacts et donc des renseignements personnels. Signera-t-on quelque chose avec Courriella pour s'assurer que les Courriella/CakeMail pour s'assurer que les données sont hébergées au Québec et que vous mettez tout en œuvre pour les protéger? Donc, une question par rapport aux données de nos clients, en fait, les données des clients de nos clients, pour être plus précis, quelles vont être les mesures prises par CakeMail Courriella?
Je pense que ce serait une meilleure question pour Kevin parce que c'est une question de processus à l'interne de CakeMail que je connais un petit peu, évidemment, pas un petit peu, que je connais assez bien. Mais si je ne me trompe pas, Kevin, non? Est-ce que tous les courriels sont hébergés toujours au Québec?
Oui, sûrement. Tous nos serveurs sont beauharnois, ils sont ici à Québec. Puis, vous signez le contrat quand vous acceptez le Terms of Use. Puis c'est tout détaillé dans notre privacy policy aussi.
C'est ça. Et puis on est en train de, pour reclarifier, Kevin l'a mentionné brièvement, on est en train de clarifier et de refaire toute la politique de vie privée pour la clarifier. Et les Terms of Use seront aussi revus. Et bien entendu, quand tous ces changements-là seront faits, on va communiquer avec les clients pour leur faire part de tous les changements qui ont été faits. Merci beaucoup pour la question. J'essaie de trouver. C'est qui? C'est Julien, Sarah. Merci, Julien.
In the chat to me, I'm not seeing any more questions. In the chat to CakeMail, Isabelle, avez-vous encore des questions?
Non, moi, je n'ai pas d'autres questions. Est-ce qu'il y a des gens qui avaient des questions plus précises sur certains sujets? On a la chance d'avoir Allen avec nous. Si vous avez des questions plus précises. Pour revenir un petit peu en arrière, juste pour vous préciser, quand on a discuté du PIA, du processus, vous avez bien compris que les documents du gouvernement ne sont pas à jour. Donc, on ne peut pas vous aider là-dessus, mais quand ce sera fait, en fait, on aurait aimé, quand on a discuté du deuxième webinaire avec Allen, on espérait bien que 8 jours avant avant la loi, on allait avoir plus d'informations là-dessus, puis on allait pouvoir parler du PIA, donc ça nous a un peu pris par surprise aussi. Mais quand on va avoir cette information-là, on va vous envoyer les liens et puis on fera probablement l'exercice de souligner les grands points pour vous aider à comprendre ce processus-là qui n'est pas encore publié. Donc, juste pour clarifier ce bout-là. Je vois pas...
Kevin, let's, while we're I think, Kevin, we can take a minute. Okay, go ahead, Allez-y. Is there a question?
Pour effacer les listes, oui, on a une question. Kevin, par rapport à la procédure pour effacer des listes de contacts et des campagnes dans CakeMail, est-ce qu'on va simplifier les choses?
Simplifier, ça veut dire...
Make it more simple to delete list of contact or campaign? En fait, les campagnes, ça n'a pas d'importance, mais c'est particulièrement les listes de contacts. So make it easy for a client. I suppose it's a client. When you're a client and you want to delete your list, will we change the process for this?
As far as I know, that is possible. It might be better a question for you, Isabel, with the product, but yeah, it will get removed automatically if it's not being used or if it is deleted by the customer. I mean, there's no sense in keeping that information. It's you know, it's obviously privacy impacted, so it will get deleted. It's, as far as making the product easier to delete the lists, that's good feedback if it's not already in the product.
OK. C'est ça, j'ai du feedback. Je vais vous contacter. C'est Lynn qui nous pose des questions, qui nous a dit que ça a été compliqué pour elle pour le processus. Donc, Lynn, si vous permettez, je vais vous contacter directement après le webinaire et puis on va réviser ça ensemble, là. Merci beaucoup pour le feedback parce que pour nous, de notre côté, ça reste assez simple, là. En fait, pour l'effacement des vieilles listes, des vieilles données, il y a toujours des processus qui sont en place, mais s'il y a des petits soucis, on va réviser ça avec vous.
Ça dépend aussi de version de CakeMail qu'elle utilise.
Oui, il y a aussi quelque chose qu'il faut préciser, c'est que avec les certaines politiques, on doit garder les informations pendant quelques jours. Par exemple, si les gens veulent se retirer d'une liste ou do you have the exact process or we're going somewhere?
Yeah, you're talking about unsubscribing. Yeah, it's important. And also if they complain that we don't email that person again. So obviously we will hold on to that address in the suppression list for that account, just prevent further abuse. And obviously that's written into Castle as well. If someone unsubscribes from your list, we have 10 business days to remove that person from the list. So once they're unsubscribed, that decision, is usually final. So it's important that we adhere to that regulation with the anti-spam law as well. So that will stay. Yeah, Alan mentioned it before. If the purpose for which the personal information has changed, or you're no longer using it for that purpose, then it should be either anonymized or deleted. So.
Yeah, there's no question. You bring up an interesting point, Kevin, and it's very germane to you and your clients. The interaction between Law 25 and Castle. And, this came up for another one of my clients yesterday. Who's not in the same business as you, but, has a business whereby certain, email addresses are collected and stored. And, there's been considerable confusion even long before Law 25 about whether a Castle consent counts also as a privacy consent under the law. And there are such strict rules now, well, in 8 days and 10 hours and 9 minutes, about consent and about how clear the consent must be, and about how very strictly you can only collect certain information. There's a bit of a tension as to whether whether Castle has priority over Law 25 or whether Law 25 has priority over Castle. That I'm struck by, I don't want to give a Castle lecture, but I know, it, Kevin, and most of your clients are familiar with it because, they must adhere to it when using your products and services. That there's that thing called implicit consent, where, you can, if you've sold someone something or have some other contract with them, you've got 2 years to send them commercial electronic messages. And there's an implied consent. That same implied consent, you're using someone's email address that you collected, for example, to send them the receipt of the purchase they made, well, can you now send them messages? Well, you can under Castle, but under Law 25, well, you collected that email address to send them a receipt, not to send them, an ad for your next sale in 6 months. So, it's a very interesting thing to see how those are going to play out. But I'm sure you have advised your clients, and I've advised my clients over the years, that express consent under Castle is way better than implied consent anyway, for various reasons. So given we now have this consent issue under Law 25, that's one much more important reason to make sure that all your consents are express. Because I'll be honest with you, if I had to make a legal determination here on a webinar, and don't, this is not legal advice in any way, but if someone were to ask me, which trumps which, privacy law would trump anti-spam law. And what's implied consent is not going to fly under the consent rules of Law 25. So, if you put a gun to my head, I would say that. And I don't even have a gun to my head, and I said it anyway. So, it's
yeah, I think it's just, it all comes down to that whole process. When that address enters your system, how clear was it to that person that they're going to be starting to receive, marketing information via email or what have you. And also for the whole privacy part of it. So I think companies just need to tighten up that process, either of having something written in there or have a link to that section in their privacy policy that they will be contacting you. And, you do by signing up or by purchasing this item that, you agree to our privacy regulations as well. So, I mean, it's just common sense, really. I mean,
yeah. I mean, 100%, number 6, I'm looking at our checklist that we put together, Kevin, and number 6, that transparency, and consent, probably should have made that number 1. Like, if we were going to prioritize them, ensuring that transparency to all individuals, and I think that's a good thing to remember for everyone here is getting back to the issue of enforcement of the law. Like Castle, privacy law is enforced as a result of complaints. And the more complaints, whether the Castle authorities get or the privacy authorities, in our case now, what we're talking about today, they get, the higher the opportunity, the higher the chance that an investigation might occur. And being transparent about your privacy practices right off the top is the best way to avoid those complaints in the first place. So you can save yourselves a lot of trouble by being as open as possible, by not doing things with personal information that you didn't tell the data subject. I like the term data subject. It's a GDPR term, but it's not used in here, but you know what I mean by it. The individual from whom you collected personal information. By being transparent with them, you avoid complaints. And thus you avoid the privacy authorities. It's as simple as that.
It also helps establish trust. I mean, it goes without saying that, wouldn't you rather be doing business with a company that has to adhere to these regulations, i.e. it's anywhere in Europe or Quebec? I mean, I personally would. Your data is safe. They have to meet these strict guidelines as soon as you become a client. So, I mean, a lot of companies in the States don't have to do that. So it's,
to add on to that fact, I have, as I mentioned earlier, I've been practicing in this sphere for 13, maybe 14 years now. And 13 or 14 years ago, the average individual knew nothing about privacy and data protection and privacy law. Ask anyone in the street what PAPETA was, or what GDPR didn't exist back then, but ask anyone, like, what happens? Are you worried about my information when I put it on the internet? And unless you ask them about PayPal, they were like, whatever. Your average consumer now is literally the opposite. And everyone has been sensitized over those 13 or 14 years. I have seen it. I can tell. And so the average individuals are now so sensitized and much more knowledgeable than they ever were, and much more conscious of the privacy and data protection practices of all companies, that, to extend your point, Kevin, they know. And they would certainly want to do business with a company that's much better in privacy than the next one over. So
yeah, I mean, the list of people who've been affected by data breaches is growing every day. I mean, it's especially in the economy today. I mean, people they're hard up. The scams out there are rampant. I mean, it's really scary. It's just a sign of the times.
I've been victim of a data breach. I mean, like it happens to all of us.
Mm-hmm. Not to be desensitized to it, but it's going to happen to me one day. It's inevitable. But I mean, yeah, if enough time goes by, but hopefully laws like this will prevent a lot of unnecessary information being leaked out. So it makes sense.
Très rapidement, parce que je vois une note assez intéressante d'un anonyme dans le chat. C'est assez intéressant parce qu'elle parle, and I'm just going to do it in English because I can speak faster in English, although I speak fast in French too. This person does not want to have to put 18. She uses the number 18. He or she uses the number 18 check boxes on a page to get consents for everything. And I recognize the tension, Anonymous, between UI UX and the law. And I was vice president of a company that built websites, for goodness sake. I know UI UX like the back of my hand. So I understand how frustrating it can be. So, but there really needs to be a balance. And you really need to make sure, look, one checkbox for Castle, one checkbox for I agree to a privacy policy. That's not 18, it's only 2. And I think that's workable.
Alan, I really enjoy your time today for taking out and spending this hour with us. I hope we answered a lot of people's questions. It's always a pleasure to have this conversation with you. Who knows, we might do this again. There's another section of the law that's coming out next September, not as much as next week, but yeah, I'm gonna call you Alan Oppenheimer. It's not so doom and gloom, everyone. It's it's very welcome. The data privacy, like I said, it's not going away. So at the end of the day, we all stand to benefit from it. So I'm happy to work for a company and live in a province where this exists.
Indeed. Thank you, Kevin. Thank you. Merci, Isabelle. And thank you to Cake Mail and to everyone who was here today.
Merci tout le monde.